Good afternoon. This is Greg Lois. Thanks for joining me today. Today's December 1st, 2025, and we are doing our annual year in review. We do this every year. We try to look back at what changed in New Jersey workers' compensation in 2025. I know it's the end of the year. We're all starting to look ahead to what's going to happen in 2026. So I also try to address some of the expected regulatory changes and rate changes that we're going to have next year. So thanks for jumping in. Thanks for joining. I'm excited to be here today. I hope everyone had a great Thanksgiving, a great holiday weekend, and got some great deals on Black Friday. Please remember this presentation is for instructional purposes only, and this is not legal advice as to any particular matter. All right, let's start talking about what we achieved last year. Let's take this time and this opportunity to kind of look back. Check out our website. You know, we're posting every month many wins that our attorneys and our paraprofessionals are obtaining throughout all of our practice in New York and New Jersey. We love to share the wins that we're getting. I think it's really helpful and sometimes even inspirational or motivational for us to share those with you. We did get a lot of case level wins in New Jersey, and we publish those all very regularly on our website. So take the opportunity to go check that out under the news and article section. Hardly a week goes by that we don't publish at least one win. So check those out and see what we're doing. Now, some things that are being changed at the court level by the Department of Labor. Well, our rates are going to increase, our benefit rates, I should say, in 2026. The current maximum temporary disability benefit under the New Jersey Workers' Compensation Law is currently $1,159. Effective January 1st, that maximum benefit will increase to $1,199. So roughly a 2.6% increase for 2026. The minimum benefit, because remember that's also pegged or indexed to the state average weekly wage, will also increase. It currently is $309, and effective January 1st, it will be $320. So temporary disability rate is increasing. The permanent partial disability rate is also increasing. And again, that is also indexed to the state average weekly wage. So you will see it increasing to $1,199. The minimum benefit, of course, remains $35 a week. So that's essentially not changing and has not changed since 1979. Let's also look back at 2025. In 2025, the New Jersey State Compensation Rating and Inspection Bureau published their annual report in which they reported 27% of the market is self-insured, 73% insured. That in 2024, which is the year that they review in their 2025 report, there was $1.4 billion in incurred losses. And the average lost time claim cost was $51,000 even in 2024. So that's just a little information to help you sort of gauge how are you doing. Are you seeing higher or lower average lost time claim cost in this jurisdiction? All right, so let's turn to the fun stuff. Let's get into the interesting stuff. What's changed this year? And this is like one of my favorite presentations I get to do because I look back at every decision that is reviewed and reported in New Jersey in the entire year. And so let's talk about that just briefly so you understand what I'm talking about. We do not look at trial level decisions. If you want to see what's happening on the trial level, go to our website, look at our wins. We summarize those for you. Those are also not published anywhere, and they don't have precedential value, meaning another trial court judge in New Jersey does not have to rely on the findings of any other trial court judge. So we don't really review them because they don't do much to change the law or to impact how we're going to practice. What we try to look at is reported decisions, and that just means a decision of a court of competent jurisdiction, which is published, and that's the court saying, publish this decision because we expect you to rely on it in the future as precedent. Now, here's some interesting facts about New Jersey in 2025. There have been 0 reported decisions. on substantive workers' compensation law interpretations. Now, there have been many unreported decisions, and that just simply means that the court, when they issued the decision, they said this is not for publication. But of course, they all are, right? We're able to get all of those decisions, so that's what I review and provide to you. Of those unreported or unpublished decisions, 33 of them were issued this year. 10 involved retirement or benefit cases, not relevant. 3 involved legal malpractice cases or ethics issues, not discussed today. And 17 involved claims against public entities. So if you look at that, you start realizing, oh, there's not a heck of a lot of case law that came out in 2025 that's going to be directly applicable to the typical employer or typical carrier. That's okay. I'm going to talk about the very few, and I think there's only 7 or 8 that we're going to look at today that do have some sort of impact and will help us give us some practical advice about what to do. So let's talk first about liens and reimbursement. And I always try, as I talk about the cases that are coming out or the decisions that are being unreported in this instance, how do we apply this? And what does this mean for you? Whether you're an attorney or you're a risk manager or adjuster, what does this mean? So let's talk about our first case. The case is called Todd versus Bowder. It was decided at the end of last year. I didn't get to cover it in my end of the year in review because it came out a few weeks. It came out Christmas Eve, actually. So it came out a few weeks. That's why I'm including it in this year. So this appeal asked the court, the appellate division, asked the appellate court to change the jury verdict, and that term is mold the jury verdict to include a workers' compensation lien. Okay, so the jury came back with a decision awarding him $21,500 in damages. That's what the jury awarded the plaintiff, who happened to be a police officer. However, that police officer had already collected workers' compensation benefits against his employer for $239,000 and change. So when the jury awards him this $21,500, obviously there's not enough money moving there to reimburse the workers' compensation carrier. And again, that's the carrier for the township that Todd worked in. Okay, so what happens? The plaintiff says, appellate division, appellate court, you should change the jury decision and increase it to include the workers' compensation lien. Because if you don't, essentially, the plaintiff, Todd, gets almost no money or no money, right? All the money would go to reimburse the carrier and to his attorney's fees. The appellate court says, wait a second, the jury didn't find or list with specificity the grounds for its verdict. And so we're not going to change that amount. In other words, we don't know if the jury didn't think the workers' compensation lien should or should not attach, because whether or not it aggravated his underlying condition or not was not reached by the jury. And so we're not going to change the amount. Now, what this means practically is that if you're a workers' comp carrier and you have a large reimbursement opportunity, in this case, the reimbursement opportunity was $239,000, and you know the claimant has a civil action that's going forward, you have options, right, to protect yourself, to make sure that maybe the jury has an opportunity to review the size of your lien. Okay, so there's 2 things that they could have done that they didn't do in this case. The first was they could have intervened in the civil action, represented themselves there and said, look, we're here because we have this interest in whatever recovery he obtains from the jury, and we want to make sure that our position is protected. So they could intervene. The second thing they could have done is they could have issued a special interrogatory to the jury. And that special interrogatory would have said, hey, jury, we need you when you're making your award to opine on causation. And that way, there would be a potential avenue for them to protect their reimbursement interest. So this case, even though, again, it's an unreported decision, it's a reported but unpublished decision, I should correct that, by the appellate division, it points out some of the issues or the challenges that can confront us when we've paid a lot of money in our workers' comp case. We know there's a civil action pending, And we have to make sure that we protect our clients' right to reimbursement from that civil action. And again, it would have been relatively simple to do in this case, but it was not done. So that's Todd versus Bowder. Now let's talk about another legal topic, which is the carrier's duty to defend the employer in the workers' compensation case. And the case that we're going to evaluate, and there's actually two cases that or decisions that came out on this topic in 2025. I'm going to discuss the first one because the second one is basically sort of like a repeat of the first one. But to understand the duty to defend, let's remember that our insurance carriers that are writing policies for workers' compensation coverage, they always have two duties. Right? The first duty is the duty to indemnify against any losses that are compensable under the workers' compensation law. And the second duty is the duty to defend a claim against an employer who holds a policy with them, right? These are the two duties. And the one we're going to talk about today is the duty to defend. So let's look at a typical workers' compensation policy written in New Jersey. These are almost all form standard policies. They always have two parts. Right? We used to call them Part A and Part B, but really it's Part 1 and Part 2. The first part of a workers' compensation policy, Part 1, always contains this language, quote, "This workers' compensation policy applies to bodily injury by accident or bodily injury by disease. We pay benefits due under workers' compensation law. We have the right and duty to defend at our expense any claim, proceeding, or suit against you for benefits payable by this insurance," close quote, right? So that's the part of the policy where the insurance carrier is saying, hey, we're going to make this contract with you, and we agree that we will pay benefits due to the petitioner in New Jersey under the workers' compensation law. Okay. And then there's a second part to workers' compensation policies, and this is the employer's liability part of the policy. Now, this, again, was created or pushed together into the workers' compensation policy as sort of a catch-all to make sure that this policy covers any other types of injuries or illnesses that might happen to the petitioner or bodily injury that isn't covered by workers' compensation. The idea, again, is to protect the employer. And so this employer liability policy, the Part 2 of a typical workers' compensation policy, says, quote, "This employer's liability policy applies to bodily injury by accident or bodily injury by disease," close quote, again, that occurs to an injured employee. But then it says, quote, "This insurance does not cover any obligation imposed by workers' compensation or bodily injury intentionally caused or aggravated by you," close quote, right? So that second part of the policy says, look, we're also going to have this catch-all clause. So we're going to indemnify and defend any case against you for bodily injury. But then it goes on to say, but it doesn't cover obligations covered by workers' comp, because remember, that's already covered by Part 1 of the policy. And it also says it doesn't cover any injuries that are intentionally caused by you, and that's the policyholder, the employer. All right, so that's how a typical workers' compensation policy works. You've got Part 1, which covers all workers' compensation. Then you have Part 2 that says, hey, this is a catch-all. We're going to also cover the employer in case there's any other weird bodily injury or illness claims that, that are not covered by workers' compensation. And then again, they include that escape clause. It says we don't cover obligations under the employer's liability policy covered by comp, and we don't cover intentional injuries, right? Makes sense. So then let's turn to our case, Rodriguez versus Shelburne Spring. This case was decided December 12th, again, just before I gave my year in review. The petitioner brought a workers' compensation claim against their employer. Later, he filed a civil lawsuit seeking damages against the employer, which is SIR Electric, alleging he was recklessly directed to perform an abnormally dangerous activity in opening an electrical panel without any training or warnings, close quote. Okay, so he brings a workers' compensation case and he is successful. He gets workers' compensation benefits. But then he brings a civil action saying, but by the way, you also are civilly liable because you recklessly endangered me. And the complaint said that, quote, employer's reckless indifference to his safety and well-being rise to the level of a Laidlaw claim, in other words, intentional harm claim, which pierces the Workers' Compensation Act bar. Normally civil actions against the employer are foreclosed or barred by the exclusivity provision of the Workers' Compensation Act. In this case, the plaintiff, in addition to the workers' comp case, asserted common negligence cases and a specific intentional harm injury claim against the same employer. Now, the carrier, the workers' comp carrier who wrote Part 1 and Part 2 of the policy, refused to provide a defense for the civil claims, saying, look, any negligence claim is barred by the exclusivity provision. And if you're wondering, that's Section 8 of the New Jersey Workers' Compensation Statute. And any intentional wrong claim is excluded both by Part 1 of the policy and Part 2. The Supreme Court ends up ruling on this and says all negligence claims are barred by the workers' compensation exclusivity bar, and says Hartford has no duty to defend the intentional wrongdoing claims under Part 2 of the policy. Because again, Part 2 of the policy, in its plain language, excludes this. So you look at this and go, wait a second, why are they even bringing this? And the answer is because they're looking for coverage for this employer. And this had to be appealed and then again going all the way up. So that's an interesting outcome. Now, I can also tell you there's another case that came out. It was decided about 6 months later in May of 2025, called Rodriguez versus Shelburne. Bunting versus Schroff, which is essentially the same case and had essentially the same ruling as Rodriguez versus Shelburne. So again, these are issues that come up to the court. And if you're in this circumstance where you say, which part of the policy applies? Do we have a duty to defend? Do we have a duty to indemnify? We now have some great case law that we can look to help us make sure we get those dismissals on the civil side and then handle the case appropriately under the workers' compensation side. Now, as I go through our annual case law review, sometimes I see some stuff where you say, oh, this is interesting. You see cases that involve workers' compensation judges. So it's interesting that one of the cases that I looked into, Turing versus Board of Trustees, involved a workers' compensation law judge who is a current workers' compensation law judge. And interestingly, in his lawsuit that he brought against the state of New Jersey, he's represented by a workers' compensation attorney who frequently practices in workers' compensation. Now, this is interesting when you start looking into the case law and you start realizing that judges are bringing lawsuits and being represented by attorneys, because I think the best practice here is for everyone to check and see if they had any case in which they were defending a case in which the petitioner was represented by Sam Gaylord or his firm, in which proceeded before this judge, right? Because there's a potential conflict there that we should be aware of. I should also say, interestingly, there was another case involving a workers' compensation judge also brought against the state of New Jersey, but there is no conflict in that case because that judge represented themselves pro se. All right, let's move along to something I'm going to call the value of trial. Okay, let's talk about a case called Makins versus Palace Rehab. The claimant or the petitioner in this case alleged injuries lifting patients as a certified nursing assistant on 2 occasions in 2018. Now, she claimed, in defense of this case, I should say, that the employer brought a pretty well-documented defense, arguing, hey, this didn't happen, it was misreported, the stories don't line up, the work duties and what she claims happened, very questionable. The petitioner testifies, and she stated, well, I did have memory problems. I was taking oxycodone. I also have residuals of long COVID and could not remember specifics about the alleged injuries. The employer incident reports that were made at the time refute some of her claims in which she, says different things and had different mechanisms of injuries. She was confronted with this at trial. Now, this, again, is the importance of trial. We get to confront the petitioner, and when they have a story that they're telling that doesn't match up with the documented proofs, with what the employer knows about the case, go to trial. Not enough cases are tried in this jurisdiction, but here's an example of a case that was tried to conclusion. And the judge concluded that, quote, when the petitioner testified about facts that were in her favor, she testified in a comprehensible, intelligible, crystalline manner. When the petitioner was asked about facts that were not in her favor, her demeanor changed and she became quiet, did not answer for an uncomfortably long time. Her head went down and she would not make eye contact, close quote. Also, the judge said that, quote, when the petitioner was asked about telling her supervisor she hurt her back with no particular incident and did not occur with just one incident, petitioner became silent, her head went down, she would not make contact with respondent attorney, she did not speak for a period that was uncomfortable, shrugging with a lack of expression. She became agitated, she tensed up, she pursed her lips, rapid blinking, a complete shift in expression with a differentiation and rising pitch saying, my memory, I don't recall. Ultimately, the trial judge dismissed the case based on a lack of credibility, and the petitioner appeals. Now, again, the importance of trial, confronting the petitioner, confronting them with documentary evidence, and then letting the judge observe their demeanor, behavior, and the way they testify. Like, that's really important. I can also tell you something. Even though cases are conducted virtually in a lot of the workers' compensation courtrooms in New Jersey, here's an example of how important it is to make the petitioner come to court to testify in front of the judge, because their demeanor is so key. Obviously, in this circumstance, you would want this person to be in front of the judge when they're testifying, so the judge can watch them and get a real sense of this person's credibility. Again, this was appealed by the petitioner after her case was dismissed, and it went up to the appellate division. The appellate division said, quote, "Petitioner would have us disregard the judge's assessment of credibility. That we cannot do. A court on review should especially defer to a judge of compensation's credibility findings, as these determinations are often influenced by matters such as observations of the character and demeanor of the witnesses," close quote. The appeals panel also thought that it was interesting that petitioner's counsel chose to have her testify despite these alleged memory issues. And again, that's a common argument that's made after someone testifies terribly. It's, oh, I was on medication. This one was interesting. It's claimed that they had complications from long COVID, brain fog, all these things. Look, they're going to throw everything at you when they have a bad trial go in. But again, I think this demonstrates the value of actually trying cases, putting the petitioner on the stand and challenging what they claim. All right, now I'm going to get into the weird stuff. This is just so weird. And this is a very Jersey-specific fact pattern that I'm about to talk about in the case of Vola, and then the next case that we're going to talk after Vola, because they're nearly identical cases. And what's bizarre and crazy here is that we get two completely different outcomes from the same appellate division just a few months apart. So let's talk about Vola versus City of Northfield, okay? This is a dual employment case. So Vola is a police officer who works for the Northfield Police Department. Now, New Jersey has something like 600 plus towns, and each town has their own little police department. And one of the way they supplement the police officer pay is they can take volunteer assignments and do things like traffic control, street control. They can escort vehicles that are doing construction, those types of things, really fall outside of regular police duties, and the police get paid on the side for these jobs. So police officer Joseph Vola, employed by the Northfield Police Department, takes volunteer extra duty traffic assignment working for some tree service that's happening in the town. Now, Asplund is a very large tree service company. They do a lot of tree trimming, particularly around power lines and to keep roadways clear. The municipal ordinance in the town says that Asplund, when they're doing this tree service, pays the city as well as has to have indemnification, hold harmless, and defend provisions, and maintain liability insurance. So they pay the city, but then the city pays the police officers, like police officer Joseph Vola, who volunteer to do this extra duty traffic assignment. Of course, Mr. Vola got injured while he was doing his traffic control duties. And Asplund Tree Services says, well, he wasn't my employee, but I'm going to contribute 50% to the order approving settlement. Okay. In other words, they're saying, I'm not really liable here, but I'm going to contribute to the settlement. Again, of course, because this is New Jersey, and you know what happens when someone gets an award in New Jersey, they bring their reopener. Vola now brings a reopener and tries to bring in Asplund Tree Service again, saying that you're my employer and you are responsible for some to pay me on reopener. Now, at the time of this reopener, Asplund argues, hey, wait a second. We never paid this person. The city paid them. There was no employment contract. We didn't hire him. We just told the city, hey, we need 5 police officers. Can you send me some police officers for this duty? Third thing, the extra duty assignment was made by Northfield, not by Asplund. They had no direct communication with the petitioner. And when the petitioner came to the tree service job site, they didn't interact with their employees at all. They weren't directed or controlled by their employees. They just did traffic control that was, sort of ancillary to the job of the tree service company. The appellate division in this case says, well, actually, both of you are his employers. He was serving the public interest of the city of Northfield, and he was serving the private interest of the tree service. So you're both his employers, and you're both liable for workers' compensation benefits. Okay, so that's interesting. It seems like the tree service had a strong, in my opinion, defense as to he's not my employee. He was just someone here providing services on the same job site, but not directed and controlled by me. He shouldn't be my employee. But the appellate division says, no, he is your employee and you are liable for benefits. Okay, so that decision came out on May 14th, 2025. And remember, this involves a police officer doing volunteer extra duty on a job site and gets injured. All right, October 23, 2025. So a mere 5 months later, we have another case that goes before the same appellate division. It's also involving a police officer, Dutcher, who volunteered for an extra duty work program, and he had an injury. Dutcher volunteered for an extra duty assignment doing traffic control for BlackRock, who was performing paving services. Now, he's sitting in his patrol car performing his traffic control duties when a vehicle driven by a BlackRock employee struck his vehicle. All right, so again, I don't know what kind of traffic control you're doing just sitting in a police car, but apparently maybe he had the flashers on so people would slow down as they approach this construction site or whatever. But that's how the accident occurred. You ready? Here's where it gets interesting. He brings a workers' compensation claim against the city. He also brings a civil action against BlackRock. BlackRock, again, this is the construction company, files a summary judgment motion saying, wait a second, you're my dual employee because you took the extra special volunteer duty assignment, and your civil action is barred by the workers' compensation exclusivity provision. In other words, if you're my employee, you cannot sue me. The civil court, the trial court, agrees. They say, you're right. He is a dual employee, right? So they're essentially arguing with the last case, Vola. Dutcher then files a legal malpractice claim against his attorneys, arguing they should have opposed the summary judgment, and if they had, they would have won. Okay. Now, here's what gets crazy. This goes up to the appellate division, and this time, the appellate division rules exactly the opposite as they did in Vola in May of 2025, and finds that Dutcher was not the special employee or dual employee of BlackRock. Quote, plaintiff was not an employee of BlackRock in any aspect. At all times, he was employed by the WPD as a police officer. He was assigned by WPD to perform an extra duty assignment at the BlackRock site. His duties at BlackRock on the day of the assignment at the time he was injured were traffic control, while BlackRock completed its job of milling the roadway. The nature of BlackRock's work is heavy highway road construction and not police functions, close quote. Quote, in addition, BlackRock did not control the work plaintiff was doing at the time of his injury. Plaintiff testifies he was in charge of the traffic, close quote. So I'm sorry, I don't see how you could read these two cases and say, wait a second, I mean, we have a police officer doing traffic control at somebody else's job site. Both times, the appellate division in the same year, 5 months apart, comes to completely conflicting decisions, right? So this decision conflicts with what the court decided in Vola just 5 months earlier and on nearly identical facts. I'm expecting this to lead to further appeal by BlackRock, because this means that Dutcher can directly sue BlackRock, and because the court restored his claims, the legal malpractice claim against his attorneys is mooted. Now, I think that may, by the way, explain this ruling. Courts try to protect attorneys from legal malpractice claims against them. So coming to this opposite conclusion to what they did just 5 months earlier gets the attorneys off the hook for the legal malpractice case, right? I'm going to keep on following this case because it's very interesting that the court gets to such wildly opposing points on all nearly identical cases. And it's going to have an impact on the definition of special employee or dual employee in this jurisdiction. So you could expect more on us from us this year on this. All right, let's move again to my favorite topic, which is the limitations of appeal and the importance of putting in a good trial. In other words, if you put in a trial the right way, you do a good job, you present all defenses, you cross-examine all the witnesses, you prevent or create a lot of issues for appeal. You kind of take care of the appeal. So let's talk a little bit about what the limitations of appeal are and why it's so important to put in a good trial and a good trial effort. In Brooks versus Rutgers, which was decided August 7th, 2025, the petitioner alleged occupational exposures to bending, lifting, mopping, and cleaning during his 13-year-long employment as a custodian caused a 100% permanent total disability. He brought in the second injury fund, noting that he had prior workers' comp awards in 1996 for carpal tunnel syndrome injuries and releases, and in 1997, lumbar back injury. The testimony included the petitioner, his treating doctors, and both sides' medical experts. And if in case you're wondering who the experts were, it was Dr. Lamb and Dr. Harwitz versus Dr. Peacock and Dr. Gallick, which, if you are familiar with this jurisdiction, you've heard those names and seen those reports many, maybe hundreds of times. Respondent's expert, Peacock, found no causal relationship, testifying there is no scientific support for the claim that the nature of custodial work leads to hand, knee, or back problems. Now, I want to stop right there for a second, because remember, in an occupational disease case, we're claiming that the cumulative effects of exposures to the peculiar nature of the work leads to a compensable disabling condition, right? And so what has to happen, the petitioner has to say, look, I did these specific motions, they were repetitive, it culminated over time, it causally related to this disability condition which I have developed, right? And there needs to be some specificity there. The law actually calls for peculiarity. There has to be something specific about the employment that leads to those specific injuries. Now, look what Peacock testified to. He said there's no scientific support for the claim that the nature of custodial work automatically or always leads to hand, knee, or back injuries. Now, Peacock did testify that the performance of work duties could have worsened the pre-existing injuries, but he actually said, quote, if you do physically active jobs, quote, it will give you a healthier, more robust physique. Okay. In other words, Dr. Peacock is saying, look, actually, if someone is doing manual work, doing manual effort, and they're exercising, like that actually usually makes them healthier. It usually doesn't break them down, right? So that is the defense's position in this case. Of course, the petitioner's expert testified that, quote, based on complaints, his documented medical history, his demonstrated loss of function, and a physiological understanding of the trauma so involved, close quote, the job duties as a custodian for 13 years were the competent cause of his disability. Respondent argues this is a net opinion. There's no basis in fact or scientific literature or any observations, right? And again, this is a common sense defense. You go, wait a second, Judge. If this claimant is alleging that his normal activity as a custodian over 13 years led to him being completely and totally disabled, wouldn't we expect that every custodian who works anywhere for 12 to 13 years is now completely totally disabled? And of course, that's not true, right? In other words, what's peculiar? And look at their doctor's testimony based on his complaints, which are subjective, his documented medical history, which again is him telling his doctors everything hurts, and his demonstrated loss of function. I'm going to find this is all related. So again, the defense's position is this is a net opinion. Now, the judge then goes and awards a 74% permanent partial total disability, right? Which is essentially the highest they can award because the 75% disability, the petitioner could argue they're actually totally and permanently disabled, but that's a very, very high award of permanent partial total disability. It also indicates, by the way, the judge was pretty annoyed with all of this because, again, that's a very high finding of disability in this case. Of course, this gets appealed. And the appellate division says we're going to defer and we're going to rely on the deference standard to agree with the trial judge who was there to listen to all the parties and listen to the witnesses and listen to the two experts. We're going to find that this was not a net opinion. The appellate division says that the absence of scientific studies to support the conclusion of causal relationship were not necessary because the case turned on the specific work duties of this petitioner versus condition to which the general publics are exposed. Now, think about that for a second. One of the defense's arguments is, hey, look, there's no study that shows generally working as a custodian doing manual labor is going to lead to total disability over a course of 12 to 13 years. Like, that's crazy. There's nothing that would prove that. The appellate division says, well, essentially, we're going to agree with the judge here. And it's not fatal to the petitioner's case that they have no scientific literature that supports their position. As long as their doctor causally relates it, and that's good enough for the judge, it's good enough for us, the appellate division. Okay. Now, what's interesting to me when I read this case, and I read it over and over again, is that the employer did not present any proofs about the actual nature of the petitioner's work. Okay. I mean, that to me seems like 101. If the petitioner is claiming that he's doing all this work as a custodian and over 13 years, that arduous labor caused these conditions, why would you not refute that? Why would you not bring something, a supervisor or a job description, which says, well, actually, here's what his jobs are. He's taking out the trash, he's mopping floors, to demonstrate what his actual work duties are. And so my big takeaway on this one is when you're defending occupational exposure cases, the facts are the key, right? Because this case proves, essentially, in my opinion, it proves that the judge can just accept the net opinion and the appellate division is going to go, well, we're going to defer to the judge on that one. We're not really looking at it. This proves to me that you have to argue the specifics and present the clearest picture you possibly can of the particular actual work duties. And you cannot just rely on, well, their doctor said this, my doctors say that. Why do you go to the heart of the matter? I mean, the whole thing is going to turn on exactly what he did at work. And there was no proofs about that were presented. So again, this is like trial 101 stuff. And it also shows the limitations of appeal. The respondent, in my opinion, makes a common sense argument like, well, judge, you can't just say he did work as a custodian. That automatically is going to disable someone, because then we expect every custodian to be disabled. That's a common sense kind of argument to make. But again, the judge is free to reject those kinds of common sense arguments. So you've got to be really thoughtful about what kind of proofs you're going to present at trial so you can actually prevail. All right. Last case we'll talk about today is Peralta versus Silverline. This case is a tortured procedural history, so I'm not going to go over it. Essentially, well, I'll just give you a little taste. This case involves multiple motions for med in temp seeking specific surgery. Petitioner gets the original surgery, wins. The second time the doctor wants to do a repeat surgery, the judge says is not related. And then they bring a third motion for med in temp, seeking to have this third surgery and determine it to be causally related. Both sides bring in experts. They're challenging the need for this surgery and whether it's causally related. It seems like a case that was litigated like crazy. But here's where it goes off the rails, and this is just something to point out. As again, as we start to think about how do we strategize and what should we be doing to prepare and put our clients in a position so they can be successful. On cross-examination, the respondent's expert revealed he has written a book omitted from his curriculum vitae, his resume, dedicated to case managers and claims adjusters, close quote, and that 70% of his income came from doing defense medical examinations. Quote, when petitioner's counsel confronted the doctor about the publication during cross-examination, his answers appeared to be uncomfortable and evasive, and his demeanor caused the judge to seriously question his candidness and inherent bias as it correlates to his one-time examination of the petitioner and review of medical records. So you guess where this is going. The trial judge found in favor of the petitioner, relying on the lack of credibility of the respondent doctor, stating his credibility was suspect, as it was clearly established that he was not a neutral and detached expert witness. The appellate panel again deferred to the judge's finding of fact and the credibility determination and finds in favor of the petitioner. Now, some takeaways here. The importance of witness preparation, in this case, was woefully inadequate, especially defense expert. This could have been planned for, and credibility argument could have been neutralized, right? I mean, again, this is trial level 101. You need to know who your witness is and know all about them. And the fact that this witness had written a book, and the book was aimed at adjusters and insurance clients, perhaps, I don't think that's fatal. But you should know it so that you can neutralize it, right? I mean, I think that's an important thing. On the second part, where the judge said, well, we learned that 70% of this doctor's income came from doing defense medical examinations, and of course, they're biased. Well, I think that's a very easy to neutralize argument if you're prepared for it, right? Because petitioners' experts are almost doing nothing but disability findings. That's all they do. It might be 100% of their entire practice. Most of them have no admitting privileges. Most of them have sort of dubious credentials. Some are general surgeons, not even orthopedics, et cetera. So you could turn that. That's something that actually would not have been, I think, fatal to the case. but it would have to have been established on the record and some preparation done. So you look at this case and you look at the judge saying, well, I'm going to find that this doctor is not credible. Again, being surprised by your own witness at trial, not doing enough witness preparation, not going over the testimony with your doctor in advance, that was the mistake there. All right, so I hope this was useful for everybody. Let me turn over to questions and answers now and just see what we have, what's going on in our, oh, well, let me just go over that page. Okay, here we go. Do we have any Q&A? Does anybody have anything for me? Let me open up the panel here. Not yet. Okay, let me check the chat, see if there's any questions. I don't see any. Okay. Well, without any questions, we'll end it here. I hope this was useful. Again, you don't get a lot of decisions in New Jersey, this year, 33, of which 7 or 8 were really applicable. That's typical, right? If we ever saw a year with 50 appellate decisions, I'd be shocked that would ever happen. But an interesting year. Again, any year where the appellate division in nearly identical set of facts is ruling 2 different ways means probably going to get a Supreme Court decision on that, or that case was settled out of court. Thanks for joining me today. I hope everybody has a great rest of your month. Happy holidays to everybody, and I will see you next year in January.